Ms. Pillai is the magistrate at the Department of Justice, and she is a practicing attorney and conveyor in South Africa. Ma'am is a noted legal trainer for Criminal Court Practice Law Society, South Africa. We are honored and we welcome you, ma'am, to the International Conference on Law and Spirituality on behalf of Campus Law Center and Ethiccraft. We thank you for accepting our invitation, and I yield the floor to you, ma'am, for your keynote session.
My salutations, namaskar, Hare Krishna. Thank you so much to the organizers for putting this event together. And I'd like to also acknowledge the presence and my greetings to the honorable ministers, members of parliament, distinguished members of the judiciary, respected members of the academia, my learned fellow colleagues, attorneys and advocates who are present. And I think more especially my message today and my presentation is addressed to the future generation of lawyers, the aspirant lawyers, our students who are possibly attending. And I feel very humbled by the fact that, and to continue from where Shubha Vilas Prabhu just ended, it's a tough act to follow because he's absolutely brilliant. And what he has said is so profound. But at the same time, I think I've got the floor right now, as much as he didn't have, and he could have spoken much more, I'm sure. I'm hoping that my presentation can build and expand on what he has already touched on, because amazingly, the topic that I have decided to speak about as well is the crisis in the legal profession. He has made reference to the fact that there's the crumbling of the justice system. And I also share those kind of concerns, although we hadn't discussed with each other. So I was absolutely amazed that the precursor to my presentation is something that I can continue to expand on. So I think it's a wonderful flow of continuity in terms of this theme that seems to be pervading currently. And so I want to speak about the crisis in the legal profession, particularly focusing on the requirement of being a fit and proper person, which also speaks to character. Like I mentioned, my topic is going to be on the crisis in the legal profession, focusing on the requirement of the fit and proper person, which appears to be generally the kind of concept that we are looking for in many regions of the world for admission into the profession itself. So like I mentioned in the concept note itself, spirituality is the progenitor of ethics and morality, which in turn have always provided a context for determining the validity of laws. Development of legal system therefore has an imprint of spiritual processes which seeks to promote peace, harmony, and reduction of conflicts in society. So I've just highlighted certain key phrases, which I think is absolutely abundantly relevant to the situation in the legal fraternity currently. The fact that spirituality is the source of ethics and morality shows us that even our ethics and morality stems from a spiritual background. And this is what is required to make our laws and our practice a valid one. This also helps with the development of the legal system. And I think most importantly is the fact that all of this, the spirituality permeates, and everything within our area of practice is based on the imprint of the spiritual processes in our lives itself. So I'm trying to, the reality of the situation, however, in stark contrast, is that it is rather unfortunate. When we look at the reputation of the legal profession, it is being tarnished due to lawyers who fall prey to greed. Shubha Vilas Prabhu also mentioned this about the issue of greed, and how people who are, the lawyers and judges who are considered to be the guardians of the legal profession and the protectors of the ideals of fairness and justice are unfortunately falling prey to greed. And this is resulting in the fabric of the future of the profession being riddled with blemishes arising from the lack of ethics, morality, and inherently spirituality. Just yesterday, Shubha Vilas Prabhu mentioned about the fact that bribes, for instance, and amazingly, I also found this last night when I was putting my PowerPoint together, this article that appeared in the media yesterday of a Durban lawyer being charged after allegedly, offering a bribe to a clerk of the court. And when I looked at this article, and this is just like 24 hours old news, it reflected that the person in question was supposedly giving a 200 rands to the clerk for finding or locating or providing him with a default judgment. 200 rands in the equivalent of Indian rupees is a mere 1,000 rupees. But it is absolutely embarrassing that, with, as much as this matter is sub judice and it hasn't been ruled upon, but the fact that this has received media attention, the public at large, general public, this is the kind of impression that they get without waiting for the finality of the case as to what was the reason for the exchange of the 200 rands, etc. I'm not here to pass judgment or to unpackage this, which is, like I mentioned, sub judice, but just to show how the media has so much of influence that reflects or portrays the image of the profession. And it is these kind of examples that eventually create and cast a bad light on the profession itself. Now, entering into the profession, many people, when they begin to enter into the profession, they are largely influenced by the image that is projected of lawyers. And as we can see on your screen right now, it's all these TV series or these movies that seem so alluring, so attractive. And what is the underlying allurement of this profession? It is the sassiness, it is that success that is portrayed by the designer suits. It is the amazing cars that are being driven. It is the affluence. It's all of these things that seem to attract people into the profession. But alas, my point is that all that glitters is not gold, and that there is indeed a crisis in the legal profession. And some of the points that one can look at for the reasons of entering the profession based on these series are the glamour, the affluence, the sharp-mindedness that appears to be portrayed by these actors in their roles as lawyers, how powerful they come across, and everything is assumed to be success. These kind of spin-offs from being a lawyer suddenly reflects one's degree of success. But I'd like to just pause for a moment and look back at the historical perspective of the profession. How did this profession originate? So it's important to reflect on the origins of the profession that earned itself the distinction of honor and respect. Yes, this was noted as an honorable and respectful profession. In Greece, in the early days, when we look back historically, it seems like the earliest traces, according to Western records, at least I must say, qualify that, is that the ranks of what we would currently say gave rise to current day lawyers came from those persons where the Athenian orators. And however, they faced structural obstacles because at that stage, these orators would be good in the way that they could speak. They were expert spokespersons. However, in pleading one's case, at that time, the rules were that no one could plead someone else's case. The person who was involved in a dispute, etc., would have to represent themselves. However, there was a proviso that you could have representation, but that would have to be assistance by a friend. And then we see how, because no one could plead another person's case except if you were a friend, these orators became friends of those who were parties to the dispute. In practice, of course, we know that this was a legal fiction and that it was, being a friend was these orators that were representing them. However, subsequently in Rome, Emperor Claudius abolished the rule that there was no fee to be paid to these orators because being a friend, one could not receive any payment. But in Rome, one could see the first time that payment of fees were officially or legally being allowed. And then too, it was limited to an amount of 10,000 sesterces. So we can see, and this is something that I want to speak about as well, is the issue of fees. So two things that I'd like to discuss is the payment of fees, which we can see historically was shied away from because it was an honorable profession and we were not in it for the fees itself, but rather for the service that we were rendering for friends, almost on the concept of pro amico. Then the second one is the admission of lawyers into the recognized profession, because there was no structured profession at that time. And we see that currently, to be admitted, and I'm using my certificate here in South Africa, when you get admitted as an attorney, there's a process other than just being armed with a law degree that one is required to follow. It's a long, tedious journey, which involves a lot of studying. And that is not just possessing a law degree is not the end of the road, at least in South Africa. And I'm not sure in other countries, particularly in India, where this conference is being hosted. And I'm assuming that one has to serve some sort of pupillage or period of articles of clerkship under a seasoned attorney or advocate before one is admitted, and write the bar exams as well. So all of it is a long, tedious journey. And at the end of the day, to be admitted in that profession is such a glorious event. So we don't really and ideally want to be struck off the role of attorneys or lawyers. We don't want to be suspended from practice. And those are the kind of things that my presentation will talk to. And I think if we look back as well, when we speak about the issue of fees, we look at the advocate's robe historically as well. There is this triangular pocket, and I'm not sure in India whether this still prevails, but I know in the South African robe with our advocates, this robe still has this little pocket at the end. Some speculation as to what was the purpose of this pocket. And I see, the robe itself brings together the functionality and the practicality of this dress code into the purpose that it serves for the purpose of my, addressing the issue of robes. It is said that this pocket historically was for the purposes of the client to put in the gold coins or the silver coins into the back of the robe of the person that was representing them, because it was actually embarrassing for the legal practitioner to openly take fees from their client, because it was the status of the profession, that fees was an issue that would become, minimize the value that was being provided. Also, the fact that it was being at the back of the robe shows that it is said that it is possible that it didn't want the amount of fees that was being put into the pocket should not have the effect of the quality of the work that was the service that was going to be rendered by the advocate. And therefore it was at the back. So he would be somewhat blind in the level of work service that he was rendering in court, and not be influenced, or rather not minimize or offer a proper service to his client because he was being paid less than what he felt he should be paid at that stage. The current, unfortunately, the current impression of attorneys and lawyers and advocates is that they are vultures preying on susceptible clients, because when disputes come about and the services of lawyers are being engaged, it's pretty much the perception that lawyers take advantage of their clients' dilemmas, their desperation at that time, and they benefit out of that particular situation. And we find that going around are many lawyer jokes and cartoons. And I know when Shubha Vilas Prabhu was just speaking as well now, he spoke about, he gave an example about whether one should lie or not lie, and that story that he related. And there's one joke that comes to mind based on what he just said, is what is the difference between a lawyer and a liar? And it said, it's just the spelling that's the difference, but both their lips are moving. And it's really unfortunate that we bear the brunt of these kind of jokes. Here on the screen at the moment, you should be seeing the situation where in a dispute, two parties, as depicted in this particular cartoon, two farmers on either end of the cow. And please forgive me, because the cow I know is considered holy, and I hope you don't find it objectionable, but this is something that is, on the internet. And this is reflecting the image of the profession itself, where two persons in dispute, the farmers are tugging on either end, claiming ownership of the cow. And in between is the lawyer who's literally milking that cow. And it's reflective of him benefiting out of this situation by milking them for fees. More jokes, that we find that are very prevalent, and once again, reflecting the nature of the fact that lawyers are seen to be heartless, they don't really care for their clients. The other one is that it's all money making as well. Now, Shubha Vilas Prabhu has also spoken about greed, and this is something that I want to touch on as well. In Bhagavad Gita, we find, that Lord Krishna speaks of this verse, and Srila Prabhupada in his purport, and I'm referring to the Bhagavad Gita as it is, whose purport is provided by His Divine Grace A.C. Bhaktivedanta Swami Srila Prabhupada. He writes and he says there are 3 gateways leading to hell: lust, greed, and anger. Every sane man should give these up, for they lead to the degradation of the soul. And if I could just read from the purport that Srila Prabhupada wrote, he says the beginning of demoniac life is described herein. One tries to satisfy his lust, and when he cannot, anger and greed arise. A sane man who does not want to glide down to the species of demoniac life must try to give up these 3 enemies, which can kill the self to such an extent that there will be no possibility of liberation from material entanglement. Because ultimately, this is what we are doing. We are entangling ourselves by this greed that seems to engulf us during the process of our practice, when we see the vulnerability of clients, etc., and their desperation, unfortunately, the tendency to exploit. And please, I'm not intending, it's not my intention to cast all lawyers with the same brush, but unfortunately, there are a fair amount of persons that have brought about this kind of perception of the profession that warrants a reference to these issues in a presentation such as this. The second point I want to move on is the law as a profession. So this author, Larson, in the journal article that was written, The Rise of Professionalism, a Sociological Analysis, back in 1997, explains that in the early days, the profession intended to include only the learned occupations of divinity, law, and medicine. So the term profession was only used in reference to these, what were perceived to be learned occupations. And as ma'am just mentioned, Seemaji mentioned, she spoke about post the Industrial Revolution. Interestingly, prior to the Industrial Revolution, class and status determined entry into these professions. In ancient India, and also reflected in Shubha Vilas's presentation as well, in the time of the Raja Rishis, one could see that the learned persons in society back then and the advisors of the king were the Brahmanas. And they were meant to guide and advise for the upholding of dharma or righteousness, which at that stage formed the legal system and the justice system itself. Over time, rules for admission into the profession were developed. Let's turn to look at what is meant by profession. How did the word profession originate? It is said that it originates from the Latin word professio, which means a public statement or a promise. And a promise, of course, means that persons in this profession are promising to uphold certain principles, certain virtues, and therefore they must be worthy of public trust. They have to carry out their professional duties with public spiritedness and the highest standards of ethical conduct. In Bhagavad Gita, and Shubha Vilas spoke about leadership as well, and this is very relevant and important for us to take away is this verse from Bhagavad Gita, where it is said that whatever action a great man performs, common men follow, and whatever standard he sets by his exemplary act, all the world pursues. So when we look at this, the exemplary acts the one expects to be followed, it is us who are in a position to influence our clients. It is us who have the position that others in society look up to. So we need to set those ideal examples. And in the purport to this verse as well, Srila Prabhupada mentions certain categories of leaders. And he mentions the kings, the parent, the teachers, as being considered to be in positions of leadership. And I would just like to say that likewise, because we teach, those of us who are in academia, those of us who are representing clients, to a large degree, we are actually influencing the future generations by the examples that we set as well. So the expectations of professionals, what is society looking to us as professionals for? The commitment to promoting the basic good in society, that is justice. We have to abide by a code of ethics. Professional conduct is regulated and enforced by a controlling body of the profession. So here in South Africa, we have what is called the Legal Practice Council. And before one gets admitted as a lawyer or as an attorney, or we now call ourselves legal practitioners, because it's now become a fused profession where there's no differentiation between advocates and attorneys. So it's the legal practitioner. So we are governed by the Legal Practice Council. And the Legal Practice Council, in their wisdom and over time, codes of conduct have evolved. So it's not just sufficient to be in possession and armed with an LLB degree to be admitted as an attorney. This Legal Practice Council has become the gatekeepers to the profession. And one of the requirements when you apply for admission in court to be admitted as an attorney or an advocate is that you need to be a fit and proper person. And to that end, you need to submit a certificate by 2 other persons in the profession who can vouch for your good character or character reference. So what is the need for this fit and proper person requirement? It is, of course, to assure the unsuspecting public that when you are admitted and you have been officially accepted into the profession, that you are trustworthy to take on their case, because these persons are literally entrusting their lives, their most valuable assets when you're drafting their contracts, when you are representing them in criminal matters, and where their liberty is at stake, and their own records, whether they are going to be saddled with a criminal record after you represent them or not. Their reputation is at stake, because there's the attorney-client privilege in which they need to feel comfortable to be able to trust and reveal everything to you so that you are properly able to represent them. So I know I'm limited for time. I'm not going to go through everything that I have originally put into my PowerPoint. Safe to say that there's no definition in any of the acts that I've come across, particularly in South Africa, as to who is a fit and proper person. So we have to rely on common law and case law. And both of these kind of reflect, as Subhavilash also pointed out, it's based on time, place, and circumstance. We see the political ethos at the time of these cases permeate into these decisions, these court judgments. And I'd just like to point out, like, for instance, Mahatma Gandhi, who's the father of the nation in India, he spent some time here in South Africa, and he applied to the court here, to the Supreme Court, to be admitted as a lawyer. But his application was opposed by the then Law Society of Natal, based on the fact that he was not a fit and proper person. And why was he not a fit and proper person? Because he was of Indian origin. So we look at how the apartheid mindset at that time as well discriminated and filtered into what was the concept of the fit and proper person. Our very own Nelson Mandela, who also became the father of our nation and was a practicing attorney at the time when he was arrested, was struck off the roll because of his political conscience at that stage. So the reality is that effective lawyering takes a lot of hard work. For those of you who are entering into the profession based on those images projected and on television, in the movies, etc., I'm not trying to be to discourage you. I'm not saying that it is wrong to be financially well off, but that should not be the goal. It will come with perseverance, it will come with trustworthiness, but it should not be the reason for the entrance into the profession, nor should greed prevail, which results in the exploitation of clients. And I think one needs to earn the respect of clients and colleagues. And when you have built this good reputation, work will automatically come to you. And in that way, you'll be financially secure. So law is a calling to serve society, not a get-rich-quick business scheme. So when we enter, we are admitted as attorneys because we have fulfill the requirement of being fit and proper persons. But subsequently, attorneys are being struck off because they are no longer fit and proper persons. So that same criteria for admission is used in the striking off. In the negative, it's phrased in the negative, that the person is not a fit and proper person. But how does someone who was initially fit and proper then falter and is being suspended from practice or is being removed from struck off from the role? And some of the reasons are as such, that we practice in an adversarial system. There's competition in the practice, in the profession. We are money driven. The education aspect as well, whether the universities are equipping us sufficiently, whether the degree itself is sufficient to make us fit and proper persons. I know that I am pressed for time, so I'm just going to very quickly scroll through these points regarding the adversarial system and then speak about it, that when we represent a client, we are actually focusing on their interests and not on the general good, not promoting the general good and looking at the outcome that will benefit both parties, which is something that appears during mediation processes, for instance. And we are focused, and it is a win-lose situation as opposed to a win situation. And we are presenting our clients' cases in the best possible light, with an indifference often for the moral merits of the case itself. And then when we look at criminal cases, for instance, and I want to just very quickly point out, for instance, like when we deal with sentencing in criminal matters, assuming your client was found guilty or opted to plead guilty, when it comes to the point of, dealing with sentencing, the onus is on the state to prove criminal convictions. And you may very well sit back and say, in the absence of the prosecutor proving previous convictions, there is no onus on you, and therefore your client should be treated as a first-time offender. So I'm not going to go into much more of this. Just going to scroll through these slides. There are many people entering the profession, but it is a struggle to source work currently. So those entering the profession tend to become money-driven, and they look for quick fix solutions, and they litigate without merit, dragging out these processes, thereby earning a bad name for the profession as well. And we become reduced to ordinary business people. So like I said, formal education does not necessarily prepare us for the moral challenges that may be faced. So which brings us to the question of morality, professional ethics, and the ultimate aim of legal training should be to enable a student to become a successful lawyer. So what is success? Success shouldn't be measured by how wealthy one is, but rather based on one's spirituality, I would say. This is a quotation from Chaitanya Charan Das, who wrote an article for ISKCON News. And I think it is very important that we know that spirituality is meant to help us develop love for God. This is done through a harmonious combination of philosophy and religion, which constitute the two rails on which spirituality runs. The philosophy aspect of spirituality involves the study and understanding of matter, spirit, and the controller of both God. And religion aspect involves the following of certain rules and regulations that help us realize and experience higher spiritual truths. So we need to integrate spiritual and our professional lives. This notion is not a new or radical concept, the integration of spiritual and professional lives. This brings about self-introspection and self-satisfaction. And that is ideally what we need to attain in our profession, to be able to go to bed at night feeling that sense of self-fulfillment. Ethics as a code of conduct is drafted, like I said, by the Legal Practice Council. It is enforced by that governing body. But your spiritual beliefs are personal choices, and therefore they will be more effective because they guide you in your practice, in the service that you render to your clients, in the type of practitioner you choose to be, and the type of service and the quality of service you render would be largely reflective of your spiritual practices. And I say your fit and proper term is like that I do when you enter into a marriage. When you say I do, at that stage, you are in the eyes of each other that perfect person that you want to form this marriage, till death do us part. But during the course of the marriage, there will be challenges, and we need to adapt. We need to build on our spirituality. We need to dig deeper within ourselves and go into those crevices within ourselves, which form the fabric of our being, and overcome those challenges through that spirituality. And in that way, we can survive this profession and, take that to the next level. So in conclusion, I'd just like to, make some suggestions of how to end this crisis in the legal profession, this reputation, this poor reputation that has been, created. We need to have a shift of mindset. When we shift our mindsets, that's when society and our clients will view us in a better light. And that would take place by the encouragement and promotion of spiritual practices, from a professional perspective, as well as from the institutional perspective of universities, where these future generations of lawyers are going to pass through those gates. We need to start beginning to instill it at that stage. And even throughout one's childhood, mentoring is another important aspect, where those of us who are in profession, and particularly those of us with years of experience, need to add value to these students' lives by leading by example, by mentoring these students. And in this way, we can effectively guarantee the future of the legal profession being restored to its original status of being a noble and honorable profession. Thank you.